Hi, I'm Tom Marks with the Marks Law Firm here in Orlando, Florida, and welcome again to the Healthy Family Law Attorney. Today I'm going to talk about the top 10 tips I have for family law clients. Okay, tip number 1, hire the best family law attorney fit for you. Okay, what does that mean? I've done a couple of prior videos where I've gone into depth on this, so today I'm going to talk a little bit more generally about this, but how do you find that right fit family law attorney for you? So I would suggest that a trusted personal friend or referral source that knows the attorney that they're going to refer to you and they trust that attorney is the best way to find a good family law attorney, because you trust the person and they trust the attorney and you come in with a high trust level, and it's a really good start. If you don't know someone who personally knows an attorney they could refer to you, then social media is an option. And things like YouTube, where you actually get to see videos of the attorney who is presenting on different topics and how they talk. It might be a little bit different in person, but at least you get some idea of their knowledge and skill set and all that. Google, Facebook, all that kind of stuff. But at least I think in YouTube, you get to see the attorney. Okay, so you want an attorney who has experience in family law. You want an attorney who actually practices family law, either exclusively or primarily. You don't want an attorney who dabbles in family law. I talk about this in my other video, like an attorney who might do criminal defense or real estate, and a family law case walks in the door occasionally and they take it, but they don't really know the statutes, the case law, the judges, because in family law you have specific judges on the family law bench. Just like in criminal, you have criminal defense judges on the bench and so forth. Okay, so number 2, prepare for the duration. So the good news is most family law cases will settle in the uncontested phase at or by the time of mediation. That's 90 to 120 days out, so 3 to 4 months. But there's a number of cases that don't settle at mediation. They go into a contested phase that can last 6 months or longer, a year sometimes. And that's when you go into court. That's when it feels more like a marathon. It's not a sprint. So prepare for that duration. If you're going to go to trial, it can take longer than a year to get to trial a lot of times. It just depends on the judge's docket and how quickly they can get you in. So just be prepared. Consider the cost. How much is it going to cost if you go beyond mediation, if you're going to get to mediation and so forth? Those are good questions for your attorney. All right, let's move to number 3. Be organized. This is the best way for you to save costs in the litigation. The more organized you are in, let's say, producing documents to your attorney, in emailing bullet point ideas of here are the potential issues or facts or witnesses, that saves your attorney time and effort and saves his or her staff's time and effort in organizing the documents if you send them all disorganized. So like mandatory disclosure has certain numbered items which ask for specific documents. If you provide them in that order in a very organized fashion, it saves the paralegals a lot of time, and so that'll save you money. So be organized. That really helps you and your attorney to move your case forward. All right, number 4, tell your attorney the good, the bad, and the ugly. You have to be fully honest with your attorney. If you hold back information that later comes out, it could surprise the attorney in a deposition because your attorney didn't know about it, wasn't aware of it, so didn't prepare you for it. Certainly, it would be potentially catastrophic if you didn't tell your attorney and it came out at trial, and that's the first time your attorney hears about it and the judge is already heard it. So it would help you. Everything you tell your attorney is confidential. So it's not like it's going to be used against you. Your attorney can prepare some defense or some type of explanation to help ameliorate or exonerate or minimize the impact of that if it's something that's going to be harmful to your case. Number 5, document everything. This can win the case sometimes. So what do I mean by that? So when you're communicating with your spouse, former spouse, significant other, whether the case is a divorce, paternity, a modification after a divorce, whatever it is, email, text, all of that, even written communications can be used against you or against your significant other, the other party, in court. So I can't tell you how many times when my client has documented something that has helped me to prevail in the case for my client. So you want to be real smart about it. You want to make sure what you're emailing is not going to be harmful to you, but you're documenting everything that you're getting from the other side, and you're communicating that to your attorney because you're part of the team. You're accumulating these facts, this evidence that your attorney is going to use ultimately in a deposition or in a hearing or in court in a trial or even in a mediation that could help the other side realize they're not going to prevail, and it could bring the case to settlement. Number 6, stay objective. I know this sounds funny or hard because it's so personal. It's a family law case. This is about your kids. This is about your marriage, your significant other, your hopes and dreams. And it's hard not to get really emotional about it. If you can, stay objective because your attorney is counting on you to help bring the case together in the sense of what are the facts that are really important that your attorney needs to know? What are some of the pieces of evidence out there that only you're going to know? Your attorney is going to find a lot of things through discovery and look at documents and stuff, but what is said between the parties, what kind of threats might be made, that kind of stuff. I do believe that it's really important for family law clients to have a good social network, family network, support network, and be in therapy if needed, because that will help you stay grounded. Those people, family and friends that you trust will obviously support you. There's no charge or cost to that, obviously. A therapist is a cost, but it's less than the attorney would be. And so that will save you money also. All right, number 7 is kind of a boundary thing. It's holding the other party accountable. So if your spouse, former spouse, significant other is acting out, doing things that are harmful, detrimental to the minor children, are not in the best interest of the minor children, then you need to point that out in a very positive way, so that when the court looks at those emails or texts and you're holding the other side accountable, they're not picking up the children on time, they're disparaging you to the children. Hold them accountable. Tell them how that's harmful to the children. Tell them how it's not in their best interest. Those emails, again, are going to be used by the court, by your attorney, to help you in the case. So be smart about it. Hold them accountable. Be engaged. Don't avoid communicating with your other spouse or your former spouse about the children. Okay, number 8. Avoid damaging your own case. That means don't send those same kind of harmful emails or texts out of emotion when you're angry or frustrated, upset, whatever it is. Those emails or texts are going to be used against you. Social media is incredibly powerful, and also can be used against you. So if you have pictures on social media of you doing inappropriate things, drug use, excessive alcohol use, whatever it is that the other side can use against you, avoid that. Your attorney is not allowed to tell you to delete anything from social media. Once it's on there, it's potential evidence, and if you delete it, it's called spoliation of evidence, and so that's your attorney's not allowed to tell you to delete it. So be careful about what you put on social media, especially what you tell others that may be used against you. There's a hearsay rule, actually an exception to the hearsay rule, that says that statements you make to others can be used against you in court, even though it's an out-of-court statement offered to prove the truth of the matter asserted. So be careful about even the words you speak to your spouse, former spouse, or whatever. Seek out support. I know I touched on this a little bit earlier. I really strongly believe in therapy, especially for clients that are really struggling through the process. There's a lot of emotion that gets involved. So if you can't afford a therapist, seek out a divorce care group, maybe at a church, synagogue, wherever you are involved. There are support groups throughout the city, throughout Central Florida. Again, family and friends that are trustworthy, that you know won't reveal things that you talk about. Seek that out, because you do need that support as you're going through this very difficult time. I know that, having done family law for 35 years, I've seen how devastating divorce can be. Obviously, I'm always going to want to try to help the client reconcile if possible, not go back into doing the same thing over and over again, not going back into an abusive emotional or physical relationship. But if we can do things differently and help you resolve or reconcile, I'm happy to do that. I'm happy to lose you as a client. I've talked about that in prior videos. Your positive trust balance, which is similar to a retainer, except ours is refundable at any time for any reason, any unused portion, because I don't want anybody to feel tied into going through with a divorce if they might have reconciled, or, well, even if it resolves before the positive trust balance is used, then yes, for any reason, any unused portion is returned. This is number 10, the final point. Stay curious, ask questions, be engaged. Don't just leave it all to your attorney to do. This is your life. These are your children. This is your house, bank account, retirement plan, assets. Ask those questions of your attorney. So questions like, why is my spouse getting his retirement plan and some of mine? Or why am I getting the house and those expenses? So those are good questions, because that helps the attorney know that he or she needs to explain the equitable distribution worksheet. There are a myriad of different ways of dividing up assets and debts. Retirement plans are not available to you until you reach certain ages. So, and then they're tax impacted then, and they're not really worth as much as they look like they're worth, because you're gonna have to pay federal income tax on them. The house you might want, but it's not an income producing asset, and it's got a lot of expenses attached, and can you afford that? And so there's a lot of different nuances in a family law case that you want to have those answered before you resolve the case. So tip number 10 is make sure you fully feel like you've gotten answers to all your questions, and don't hesitate. Don't be shy. This is your life. So get those answered. I know it's a very stressful time, and that's why you want to get the right attorney. You want to get the support you need. You want to get the answers to the questions that you have and not feel like you're being a burden. Okay? So I believe your family matters, and so I want to provide hope and help to your family to successfully navigate the family law process in a healthy way. Thank you so much for joining the channel today. Please like and subscribe, hit that bell icon, leave a comment. Would love to hear from you. Have a great week and hope to see you in the next video. Bye.